Citizen fails in court. You know, I saw a lot of people posting this on the internet, so I thought I'd give my 2 cents. I got a chance to look at all the comments under the video I posted. Man, it's amazing that these videos attract so much attention, and they think people are stupid for coming into court trying to assert their rights, or they think they're based off of some complete nonsense. When, let me just ask you, people under the comment section, tell us what money is. Explain to us what public and private is. Explain to us the application of the Constitution for the United States of America. Is there money? Explain to us what happened in 1933. Explain to us the purpose of a Social Security card. Explain to us who the Federal Reserve is. If you can't answer any of these questions, shut up. Anyway, here's my review.
Court does call the case. Peninsula Place versus, is it Trellis Lane? Yes.
Good afternoon, Your Honor. David King here on behalf of the plaintiff.
Sir, your name?
Oh, sorry, Judge. Trellis Lane.
Okay, this is a matter of concern with a lot of people in the Patriot community, and that is in answering to the name. Is answering to the name granting jurisdiction? Because we know that the all caps name is a legal fiction, or it's an ens legis, it's a creature of the state, because public and private don't mix. Everything in the public is essentially a legal fiction or some sort of persona, which comes from the word person. These are persons in the public. For all of you anti-sovereigns out there who are wondering why they're not answering to the name, well, that is the reason why. I tend to think, though, they have come up with ways of circumventing that, and it would probably be just more effective just to state your name, then spell it in the Christian appellation as, say, my name is capital J, lowercase o, capital lowercase h, lowercase n, capital D, lowercase o, lowercase e, you know, something to that effect, and then state that I'm here as an authorized representative, or I'm a beneficiary of the trust, and state your position, because we believe that it's not so much the name, but it is in your relationship to the name that is of concern. All right, but for those of you who wonder what is the situation with the name, that's it.
All right, this is the date for non-jury trials, and this is a non-payment of rent case. How much is the plaintiff claim is owing?
Your Honor, the total balance at this time is $3,320.17 plus court costs of $161. $3,320.17.
All right.
Hey, Your Honor,
Sir, of that amount, is there any that you believe that you owe?
no.
You were going to say something.
I was going to ask to object what he was about to say as far as about the numbers. About saying what I owe, but you already answered the question. I mean, ask me the question.
Okay, first and foremost, I want to bring everybody's attention to the fact I didn't see where he was sworn in. If you're not sworn in the proceeding, then everything that you say is hearsay. And I didn't get a chance to really see if he knows how to object, objection, Your Honor, or whether or not there was a question, are we on the record? Are we on the record? You're not there to speak to the judge, you're there to speak to the record, to make a record for appellate purposes. So I didn't see all that, but it's just my little tidbit I'm throwing in.
And
I
Mr.
can break
Finn,
down that amount if you want me to, Your Honor.
pardon?
I can break down the amount if you'd like me to.
Just one moment, we'll get to that. Sir, can I ask you, I received the documents from you. Is there a reason why you don't think you owe that amount?
At this part right here, he says he received his documents. Usually when you're trying to discharge debt and you have a court appearance, you are going to give a judge heads up. You're never going to surprise the judge and just come in with, all this, what people like to term sovereign citizen type things. But it is just, it's a commercial remedy, and it is a private remedy, and it's not really made for the public. But he sent some type of documents to the judge. I'm not sure what they were or what they entailed or anything like that.
Because it's already been paid, Your Honor. Far as...
Okay, right here, he's using the word pay. Anytime you use the word pay, you just signed your death sentence. Nowhere in HCR 192 of June 5th, 1933, Public Law 73-10, all associated policies, along with Title 31, 5118, which is the rescission of the gold clause, does it talk anything about you being able to pay for anything? You can't pay for anything with negotiable instruments. These are negotiable instruments. What you're doing is doing a set off. It is a discharge. It falls under set off. Okay, so right here, anytime you see anyone use this word pay, if you use it in any proceeding, the judge is playing with you from that point on. You're dead in the water.
Reporting adverse information about a Co-Signer Act 211 of 1989. Vanessa Place is trying to held me liable as the co-signer when I have an interest and a signature and I'm a natural person.
I'm not sure what he means right here when he's talking about signature. I think he's alluding to the fact of the difference between a signature and an autograph when both are signed by a real living soul. And I'm not sure if he used a blank endorsement or he qualified his signature. This is all missing information. I'm not sure if he signed, how he signed his name or anything like that. So this right here remains to be seen. But I believe this is what he's referencing when he says I have an interest in something.
So they're trying
Okay,
to
so
go viable.
okay, so let me ask you this.
Okay.
Just so that I have the background on it. You reside in this unit that's at I think 315B
Correct.
at 1000. You reside there.
The judge is asking him, does he reside there? This is not an innocuous question. This isn't a question that establishes jurisdiction by having the defendant testify against himself. You have the difference between a resident and a domicile. When I'm domiciled or I'm a resident somewhere, he said he takes up housekeeping there or he abodes there. I think that's what he said. That's his abode. The reason that he answered like that is because of the word resident. Resident is a commercial term that establishes you under their jurisdiction. And this is the reason why he is not wanting to use the word resident or affirm what the judge said. Do you reside there at this particular address?
That's my place of abode.
Well, you live there, right?
Depends what you're talking about. I'm acting as a consumer. So, far as like I'm there on special appearance and my estate stays there. But as far as a natural man, I don't have no place.
It's things like this that makes why they think sovereign citizens, and there's no such thing as a sovereign citizen, but they think people coming in with these defenses are crazy. Because it does sound crazy. It sounds crazy to me. I even understand what he's trying to say, but it still comes off as crazy. My estate saying, because my state stays there, I'm coming in as a consumer. This is when you get into this thing. What I try to tell people, they try to use a lot of words they don't really understand to try to sound sophisticated, when you should just keep it simple. Like just say, hey, look, man, I'm a real living soul. It's my understanding that a resident is a legal fiction entity that resides within your jurisdiction. I'm a real living soul. I'm not here to willfully engage or submit myself to this particular jurisdiction. So, Your Honor, this is my domicile, or this is where I abode at, and that's it. At the end of just something like that. I'm just saying something off the top of my head. But stop trying to make things sound so sophisticated. My state stays here. He's talking about the all caps name. You get into some legal fiction terminology, or just say, well, you know, I receive correspondence and care of this address, or something like that. You know, just don't try to figure out. But what I'm trying to say is try to figure out how to use language that's not going to make you sound like a sovereign citizen.
As far as my estate and my,
Okay, so when whoever is in this courtroom leaves here to go to what they would call home, where does this person that's sitting here go?
to my place of abode, Your Honor.
Which is where?
A Plymouth place.
Okay, at the 315B.
Correct.
All right, that's what I need to know.
Really, all of this discussion, I mean, all of this is just ridiculous, first and foremost, because he's in there on rent. He does not own this property, and you cannot force a person who owns a property to take a negotiable instrument or to take a discharge. It is the government is the only one that is responsible for discharging a debt. But the judge went at length to establish jurisdiction. All of these were jurisdictional things, because he could see from the offset that he's not trying to grant jurisdiction. He's making a special appearance, which special appearances are allowed on the state level. They've been done away with on the federal level, but they exist on the state level. All right, you have a special appearance and a general appearance. Special appearances are reserved to challenge the jurisdiction of the court. So this is why they're having all this banter back and forth, unbeknownst to the audience, because most of the people watching this, they're ignorant about all this, especially people are going to be in the comment section. But this is what this was all about. He was going back and forth with this judge. This is this judge's sly way of establishing jurisdiction, of confirming that the court does have jurisdiction, because the court cannot move forward, because you can attack subject matter jurisdiction at any time. At any time. Subject matter jurisdiction of a court can be challenged at any time.
Do you have a ledger?
And I'll give Mr. Lane a copy also.
Thank you.
Another reason you do a secure party process, because you use the UCC commercial chamber to ledger all of your debits and credits that are associated with your account. You have a record.
And Mr. Fantera, this would be your witness, is that correct? Okay, why don't we do this? Why don't we have her and Mr. Lane sworn in, please?
Thank you.
Yeah, one minute.
Right hand. Swear affirm the testimony you're about to give.
I do.
Raise your right hand. Do you solemnly swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, so now they're sworn in, and they will always ask you whether you swear or affirm, and you always affirm, because the Bible, which is where all these courts come from the Chancery courts, courts of equity, tells you not to swear.
Your Honor, could I give you real quick context on that?
Yes, please.
We had a previous case last summer where Mr. Lane received SARA funds. And when we had I have a copy, I have a case number, I have a copy of the unsigned copy of the COD. That was entered on September 9th. SOS paid his rent through September, and it left a small balance of, I think about $119, which we waived. So the balance, even though it doesn't show it on there because we didn't actually get the SOS check till sometime later, his rent at the end of September was $0.
Got it.
So the total balance that's on there is 5 months of rent at $513, water and sewer bills, electric bills. There's not even any late fees. and then there's 161 in court costs. So I just wanted to clarify that, in fact, none of this goes back past September 30th.
Were you recently injured in a car accident?
In fact, I don't know if you remember, we actually, when we had the previous case, Mr. Lane had sued Peninsula Place seeking the return of all money he paid forever. And he denied that he owed money, but simultaneously applied for Sarah, and he denied he applied for Sarah. You verified with probably Aaron at the time that he had applied for Sarah. He ended up getting Sarah funds. He would not sign the COD, and then you basically gave him a choice. I'll enter the COD, or we'll have a trial and I'll give you a judgment. But it sounds like he's raising some of the same stuff now that he attempted to raise.
Your Honor, free to speak?
Go ahead, sir.
So, Your Honor, when I applied so at first I didn't know what I was applying for.
You didn't know what you were applying for?
So when I applied for Sarah funding, I ended up giving my principal information, which was my name, my date of birth.
Okay, I had to go and do some research on, because I kept hearing this word Sarah funding, and I really didn't know what Sarah funding was. And this is in Michigan, actually, and you can see it's the COVID Emergency Rental Assistance. So now I'm beginning to build a picture of what happened. You know, there was a moratorium on, kicking people out and foreclosures and so forth during the COVID situation. And now that that's over, they are evicting people. There's going to be a lot of evictions and things of that nature. And so now this individual is looking for a quick fix, which is something I don't like individuals to do. That's why I have a school. It takes a long time to learn this information, but people will run out and go learn something real quick and then try to use it as some sort of defense because they have some sort of exigent circumstance that they are trying to take care of, and then leave a long line of bad case law on the books for these people to access and say, okay, you are just another one of these crazy sovereign citizens. But I had to check. This is the COVID Emergency Rental Assistance, which means that you took a benefit and a privilege from the government, which is also is going to constitute another minimum contact and grants jurisdiction over your person. And that's why they're bringing it up. Nothing that's being brought up is not being brought up for any reason. You know, to the casual observer, it may appear to be so, but for those of us who understand jurisdiction and understand how there's nothing in these court cases that said just with, for no reason. You know, this is the reason for that. You're taking benefits and privileges, and now that's like the Ashwander rules. And if anybody's familiar with Ashwander, it's regarding, the rules of constitutional avoidance if something is unconstitutional and how the Supreme Court looks at it. And they have 7 rules regarding that before they'll take cognizance of something. But right here, number 6 is constitutional estoppel. A party cannot challenge a law's constitutionality when he or she enjoys the benefit of such law. In other words, if you're taking a benefit and a privilege from something, you can't later on go and back and challenge it and call it unconstitutional when you have profited from it in some sort of way. Here, he has profited from the assistance of the state, and then he wants to go in and make all these challenges to the court's jurisdiction and things like that. And it's just nonsense, and it's not going to work. And many of you out there, it's the same way. I have to come in and say these type of things because, it's a lot of people out there in the patriot community. They really do think they can just do anything. And that is the problem. It is no. I'm here to dispel that. You can't just do anything. Either you're all right or you're not right at all. You're either private or public. You can't be both. They don't mix. You can't be mixing them. You got to live your life completely in the private if you want to be outside of their jurisdiction. And one of the ways of doing that is taking everything out of your name and putting everything in your business name.
My social security Social Security number. Basically, I'm here today saying that I gave my principal to Peninsula Place and I've never received any consideration.
Okay, let's look at consideration real quick. Consideration, this is coming out of Black's Law 8th edition. Since one, something such as an act, a forbearance, or a return promise, bargained for and received by a promisor from a promisee, that which motivates a person to do something, especially to engage in a legal act. Consideration or a substitute such as a promissory estoppel is necessary for an agreement to be enforceable. See Restatement Second of Contracts, subsection 81, 1979. Okay, and let's look at the expert commentary. A consideration has been explained to be any act of the plaintiff from which the defendant or a stranger, which is a legal term too, that word stranger, derives a benefit or advantage or any labor, detriment, or inconvenience sustained by the plaintiff, however small the detriment or inconvenience may be. If such act is performed or inconvenience suffered by the plaintiff with the assent, express or implied, of the defendant, or in the language of pleading, at the special instance and request of the defendant. Okay, so he has received consideration. He has a place to stay. And one thing that people need to understand, and there's a natural law principle, that in order to give, in order to receive, you have to give. There's nothing free in the universe. Everything is about exchange. Everything is about exchange. So the plaintiff did incur a detriment because they gave up their property so this gentleman could stay in it under an agreement that he would provide some sort of value for that, the value that is acceptable to this private party. This is not the government we're dealing with.
Your Honor, I don't understand what that means. I have a lease here that is between Peninsula Place and Trellis Lane. It's not between the estate of Trellis Lane. It's not with, I think I saw somewhere here something that he recorded with the state of Michigan.
Here is the point of contention that anyone who has been attempting to learn commercial remedies or to conduct commercial remedies, especially in the court proceeding, this is something that we all have to contend with. This all caps name. See, there's going to be a lot of people in the comment section who are talking about sovereign citizen things and they don't exercise common sense or awareness. When they look around, they look at their senators' nameplates in all caps, the name on your driver's license in all caps, your birth certificate is in all caps, the names on all of your utility bills in all caps. They don't think that that means anything. They don't think it means anything. They think, oh, they just put it in all caps. When we know and we understand that in the public only has legal fiction entities in it. Everybody in the public has a title, a name and a title. Public means government. So public can only interface with other artificial entities. So they have given everyone an estate or an all caps name. You see it reflected on your social security card as well. And this is also something that is very difficult to prove because they have concealed this so much. So it leaves it open for you to get attacked in the public and say, oh, you're a crazy sovereign citizen. You believe, this is what they believe. They always trying to tell you what you believe, but they never, present any type of evidence to the contrary. Like you won't find anybody in the comment section that will provide evidence or a reason why are they putting everything in all caps. This is a very, very, very point that is over the years people have been trying to get to the root of this. We have the Styles Manual, the government Styles Manual that people bring up and so forth, but there's really never been any type of compelling evidence other than just observation or just the knowledge of the fact that public and private doesn't mix, that we have a private and we have a public, and corporations and real living souls cannot interface with each other because a corporation is a construct of the mind. If they say that, just for all the listening audience, if they say that the state of Georgia has a claim against you, and I say I call the state of Georgia to the witness stand because I have a right to face my accuser, they'll try to make me look like I'm crazy, but you're the one crazy because you are sitting here talking about something that is something that somebody made up in their own mind and trying to act as if it is something real. but I'm the one that's crazy.
Certificate of assumed name, TTL LLC. The lease is with Trellis Lane, who is a person.
Okay, this is a very, very important point. This word person, this is probably the most important thing, word that people just gloss over and no one pays attention to. But any serious study or anyone who's even done a cursory investigation into the subject of the person will understand that the person isn't referencing a real living being. Even in William Blackstone, okay, he had articles discussing this. I put a link to an article by the Informer in this video for everybody who would like to study what a person is, because it sounds like an innocuous term, but you'll hear it thrown around in the legal community because they understand and know what it was. But the laymen who watch videos like this, who make sovereign citizen comments in the comment section, have no idea what a person is. And I will challenge any of you to put in a proper definition of what a person, to do some study, to do some serious study on the particular word, what a person is.
And Your Honor, I took control of my name. So that means all interest and consideration will be coming on to me.
Why is he in here talking about taking control of his man? I know what he's saying. He's saying he took control of his straw man. But why would you be in court using terminology like this in the public as if everybody knows what you're talking about and they're going to agree with you? You look foolish. And how everybody is viewing him is deservedly so.
Okay, I again, I don't know what that means. However, are you Trellis Lane?
This is a very important question that at any point or sometime in a proceeding you're going to get asked, whether or not you are this person, okay? Because they understand what is going on and they need to see if you're swift enough or can provide an answer to their satisfaction of this. Denying you that not that person doesn't work anymore. They used to work in the old school when you say I'm the authorized representative of this or that person or whatever. But today, you don't need to do all of that. You could say something to the effect that, yes, and my name is spelled capital J, lowercase o, lowercase h, lowercase n, capital D, lowercase o, lowercase e, for the record. That is the Christian appellation of my name. I'm a real living soul. And yes, this is my name, because you have something called you have something called an item sonen, which means same sound. So this all caps name and Christian appellation of your name sound exactly the same. This is some of the trickery that is being used in law to deceive people that the layman is totally unaware of, and it makes you look foolish in the public.
That's a yes or no. Because I'll tell you, if you are, then we'll go ahead with the trial. If you're not Trellis Lane, then I'm going to give them a judgment by default because Trellis Lane hasn't shown.
I'm here on special appearance.
No, you can't do that. You are not an attorney at law because you can't appear for somebody else. So my question is, and I'll ask it again, are you Trellis Lane?
Okay, right here, the judge demonstrates his experience in dealing with situations like this, because he told him he can appear for anyone because he hasn't identified himself. So as such, he's trying to make an appearance, a special appearance, but you can't make a special appearance until you've identified who you are. This is why those I'm not that name argument does not work. You have to basically make an appearance under that name, but the Christian appellation of your name. But right here, this right here just is telling, it shows you that they are used to dealing with people like this. They've had meetings and they are prepared for you. They're prepared for you.
Yes, Your Honor.
Thank you. October of 2022. Did you pay rent to the landlord?
Yes, Your Honor.
Okay, and how did you pay that?
Okay, this word pay is deadly, and this judge just called him. He's caught up in saying, pay, we discharge and set off. He's attempting to do a discharge and a set off. You can't pay with any of these processes. I don't know why people continuously try to buy things and do things with it. That's not what HGR 192, June 5th, 1933, Public Law 73-10, and all associated policies is referencing. You can't do that. And just by using the word pay, you're dead in the water. How can you pay for anything, first of all, when there isn't any money? And that's the discussion that's going to entail from this point on. Well, how did you pay for it?
I'm paying with my credits that's on file. So I sent instructions back in May.
This was just very painful to watch. You know, he's sitting here trying to explain, giving processing instructions how to zero out his account every month. There is a document called Zero Out Your Account. I'll put the link to it in the description. Once again, that's not for them to zero out the account. That's not, you have to set, you're a private banker. You have to make presentment and then you have to get them to make presentment by giving them a negotiable instrument and then giving them instructions on where to make presentment on that negotiable instrument. I'm not hearing any of this. I don't know what type of instructions that he gave him. I'm not even familiar with this process. And this is another thing that people like this individual, he'll appear in court and everybody will think that we all do these type of things or all have the same kind of processes. And that's just not true. I'm not really sure what type of instructions that he gave him or exactly what he's trying to do. But there is a link in the description to zero out your account.
Basically, to get my account zero every month.
You do what?
I sent instructions back in May, then I sent another one to December to the CEO.
The CEO of what?
American Campus Communities. Saying it right. So he's seen my email, so he's aware of what's going on. Basically, like I say, I'm looking for consideration. I have not been getting no consideration, no adequate consideration.
Well, you get adequate consideration for the contract and any payment by virtue of the fact that you have a residence. So I don't think consideration is even an issue.
But Your Honor, I have several questions.
Well, you can go ahead and ask your questions, but I don't know. Let me just ask this. October 2022, how did you pay your rent?
I paid with my endorsed, took the bill, I endorsed it.
Did you give them cash?
Okay, and this is another situation that it's some information that's been passed down for a long time about usually use a voucher like you see right here where you can convert the voucher into a negotiable instrument, but this requires you to understand all the necessary elements that need to be present to make something a negotiable instrument. The person that really introduced this was a guy named Douglas Riddle years ago, I think around 2010 or so. I put a link to the video. Go and listen to that audio and then come back and listen to this so you can get a full understanding of exactly what it is when he's talking about he's endorsing, giving his endorsement and things of that nature. All right.
We don't have,
We being whom?
I'm saying it's a credit system, Your Honor.
So what?
Credit system. We don't.
So who's in charge of this credit system?
You said who's in charge?
Surely.
I mean, we haven't had money since 1933, the American Banking Act.
We being whom?
As
Who are you talking about when you say we haven't had money? Who is we?
far as like the United States haven't had money since 19.
Oh, they definitely have, and I spent my share. So I don't know.
Okay, this is a lie, and the judge needs to be called out on it. He could have easily have put a document in called the affidavit of Walker Todd, who's an expert witness who worked for the Federal Reserve. That is what primarily you want to use in situations like this when they try to raise vapor money arguments and things of that nature. You also want to come in with the Federal Reserve Modern Money Mechanics issued by the Federal Reserve in Chicago. And also you can, the Financial Accounting Standards Board statement number 95 on page 21 under financial institutions, where it talks about how banks create money out of thin air through lending. There isn't any money. Money is created through debt. What they call money, we have two kinds of money, which is money of account and money of exchange. What we don't have, what he doesn't understand, is we don't have money of exchange, which is constitutional money. What we have is money of accounting, which is what he's attempting to do, and why this judge is trying to make him look like a fool out in public right now, because they don't want the general public to understand all this. The only thing that constitutes money is gold and silver. Everything else is credit. Okay, right here you can see J.P. Morgan. Right here, a little meme of him, telling you this, only gold and silver is money. Everything else is credit. A lot of people don't understand that. They don't understand the financial system. This judge needed to be called out on that. You say, I will conditionally accept the judge's contention that there is money upon proof of claim. You can provide me some sort of statutory evidence or something to the fact that would demonstrate in this court that there is money. He just said there's money and he spent his fair share. That's not a fact just because he said it. You have to challenge the judge on that point. Don't let them get away with that. Do not let them get away with that.
You're saying you gave them credit.
Yes.
In what form did you give them credit in the month of October 2022?
Then credit, I took the bill, which they give me a bill every month, which is a statement. I take the statement. If you want to, I can show you.
Yeah, I know what he's referring to. Can I show you?
Yeah.
Well, show him, and then
I got copies for him. Here's what he's getting, Your Honor. We have a third-party billing company called Zigo, and so what they do is every month they bill the utilities. So he gets this bill. And then you'll see at the bottom, what he writes is pay to the order of Peninsula Place. And so what he's taken, so for example, the top one says pay to the order of Peninsula Place, $662.12. That amount is his monthly rent plus the $123.12 in utilities that are at the top. There's 3 of these that I've attacked. So what he does is he cuts off the bottom and he mails that in as with instructions to pay to the order of Peninsula Place, as if that's a check.
Once again, this individual just doesn't know what he's doing. First of all, when people are doing this, it's paid to the order of the United States Treasury, because the federal government is the one that is responsible for setting off debt or discharging debt, as it says in ACR 192 of June 5th, 1933. It's not these individuals' responsibility. And on top of the fact that you can't pay for anything, you can't do this with rent and things of that nature. I'm tired of people trying to say, well, I did it with rent. Well, and I got proof. You don't have any proof. All right. Just because something got paid, there's no way in hell, unless you work inside the bank and you got access. The only person who has access to that is the president of the bank, not even the vice president, or has any access to any of this information. Just CEOs and CFOs of banks have this information. Okay. You don't have any proof to attest to that. Only way you can find out whether or not this works is to do it yourself. Okay, but it's not meant for this purpose. Okay, it's not meant, and this is going to be the result of that. They're going to come out, they're going to make you look like a fool and try to make everybody look like a fool. That's all that's going to happen. This individual doesn't know what he's doing. He's using information he probably was passed on to him. He don't even know the source of it. Like I said, check out the Douglas Riddle audio. At least you can start to understand the foundation of all this information instead of just listening to other people.
Have this marked as plaintiff's exhibit and 2, the ledger being 1. But Mr. Lane, you have a copy of what I've marked as plaintiff's exhibit 2. Is what Mr. Fantera described, is that correct? Is that what you do?
Yes, I'm accepting the credits that's given to me, and I'm transferring it back.
Who's giving you this credit?
And this is where you can get jammed up and begin to look foolish, and why you have to learn how to be a private banker, and why I tell everybody, I don't care what process you do, go through the secure party process so you can understand this. Okay, where are the credits coming from? Okay, there's no secret account at the government. The account is on the bond. You have to understand what a holder in due course is and what a holder is, and how negotiable instruments work, and how the government becomes the holder, and how they have a fiduciary responsibility in the retention of that bond to discharge debt, and then the process that you have to go through to discharge that debt. It goes through the government. It doesn't go, and he's not able to explain it properly. He's not explaining it because it's banking. It's simple banking, no different than they do in the public with a check. You know, when you write a check, you got to take it to the bank. A check is a three-party instrument. So you need to know how to put together a negotiable instrument, usually a bill of exchange or something that affect a three-party instrument. A three-party instrument is utilized instead of a promissory note, because a promissory note is a two-party instrument. With a three-party instrument, that is how the government is involved in. They are the financial institution, you are the issuer of that instrument, and they are the payee of that particular instrument. And this is something, these just fundamental things you have to know before you start getting into negotiable instruments. You're sitting up here and you're in court trying to explain something, no evidence to substantiate anything that you're saying, no evidence of anything. You didn't even give a negotiable instrument that required some sort of presentment so they could come in court and say, okay, well, there were insufficient funds or there was something of that nature. You didn't do any of those things. You just gave your signature.
They who?
So Vanessa Place, so in the beginning, when I signed up with Vanessa Place, I gave my principal information. So those payments are supposed to come to me as credit. So
what payments?
The payments that's coming every month. So those payments, they're trying to hold me liable for it, and I'm taking the credits that I'm receiving and dishing it back to them, to Vanessa Place.
Who's giving you credit?
You said who's giving me credit?
Yeah.
I have credit, Your Honor. I have a security interest.
In what?
And this so-called contract with Vanessa Place.
Okay, but who's giving you credit? Young man, you keep using these terms, payment, credit, and it seems to me as I'm listening to you that you're using them improperly. So my question is, have you paid anything to the plaintiff in US dollars or anything that evidences US dollars?
Okay, right here, we're going to have to get to the bottom of the root of what is money, because this judge keeps talking about paid in US dollars, and we have to come to a determination, well, what is US dollars? Money is whatever the United States says is money. Is whatever they say, whatever they agree is what money is. There isn't any constitutionally mandated money like gold and silver that's in circulation, because that was eliminated after 1933 under President Roosevelt with the New Deal program, which gave everybody social security numbers and made everybody essentially dependents on the federal government. But right here, this is Walker Todd, who worked for the Federal Reserve. And let's see what he says about money. The first thing I want to do is I want to get this guy's credentials out of the way. As you can see, this is in the circuit court for the county of Oakland. This is in Michigan as well, right where they're at right now. All right. And you can see this Bank One. Here's the case number. People can look this up. Affidavit of Walker Todd. Walker Todd is an attorney that worked for the Federal Reserve. Let's look at him, his professional background and qualifications. My qualifications as an expert witness in monetary and banking instruments are as follows. For 20 years, I worked as an attorney and legal officer for the legal departments of the Federal Reserve Banks of New York and Cleveland. Among other things, I was assigned responsibility for questions involving both novel and routine notes, bonds, bankers' acceptances, securities, and other financial instruments in connection with my work for the Federal Reserve Banks, discount windows, and part of the open market trading desk function in New York. In addition, for 9 years, I worked as an economic research officer at the Federal Reserve Bank of Cleveland. I became one of the Federal Reserve System's recognized experts on the legal history of central banking and the pledging of notes, bonds, and other financial instruments at the discount window to enable the Federal Reserve to make advances of credit that became or could become money. I've also read extensively treatises on the legal and financial history of money and banking and have published several articles covering all these subjects as just mentioned. I've served as an expert witness in several trials involving banking practices and monetary instruments. A summary biographical sketch and resume, including further details of my work experience, readings, publications, and education, will be tendered to defendants and may be made available to the court and to the plaintiff's counsel upon request. So I think that qualifies him as an expert witness. And he gets in here talking about generally accepted accounting principles, which is GAAP, which is something that we all need to understand what GAAP is, that all banks use GAAP accounting. But let's get right here to the relevant of subtle distinctions about types of money. From my study of historical and economic writings on the subject, I conclude that a common misconception about the nature of money, unfortunately, has been perpetuated in the U.S. monetary and banking systems, especially since the 1930s. In classical economic theory, once economic exchange has moved beyond the barter stage, there are two types of money: money of exchange and money of account. So right here we see there are only two kinds of money: money of exchange and money of account. Money of exchange, I can already tell you, is gold or silver or certificates that are redeemable in gold and silver, and then anything else of account, which is accounting, which is basically credit. For nearly 300 years in both Europe and the United States, confusion about the distinctiveness of these two concepts has led to persistent attempts to treat money of account as the equivalent of money of exchange. In reality, especially in a fractional reserve banking system, a comparatively small amount of money of exchange, namely gold, silver, and official currency notes, may support a vastly larger quantity of business transactions denominated in money of account. In other words, when you learn the history of money, they would have gold. They would only keep 10% of the gold to show people and then loan out all this other gold and invest it in all these other places. This is where this 10% reserve came from today. For every dollar you put in, they loan out. Where every $10 you put in, they loan out $9. So they have $1 supporting all of these other transactions. You know, the 10% is in this fractional reserve system is supporting a large amount of credit notes that are in circulation that aren't backed by anything. And we see right now the banks are collapsing all over the place. All right. So it goes on. It says the sum of these transactions is the sum of credit extensions in the economy. With the exception of customary stores of value like gold and silver, the monetary base of the economy largely consists of credit instruments. Against this background, I conclude that the note, despite some language about lawful money explained below, clearly contemplates both disbursement of funds and eventual repayment or settlement in money of account. That is, money of exchange would be welcome, but is not required to repay or settle the note. The factual basis of this conclusion is the reference in the disbursement request and authorization to repayment of $95,905.16 to Michigan National Bank from the proceeds of the note. That was an exchange of credit. A Bank One plaintiff for credit apparently and previously extended to defendants by Michigan National Bank. Also, there's no reason to believe the plaintiff would refuse a substitution of credit of another bank or banker. Notice here it said bank or banker because you're private bankers. As complete repayment of the defendant's repayment obligation under the note. This is a case about exchange of money of account, credit, not money of not about exchanges of money of exchange, lawful money, or even legal tender. Ironically, the note explicitly refers to repayment in lawful money of the United States of America. See promise to pay clause. Traditionally and legally, Congress defines the phrase lawful money for the United States. Lawful money was the form of money of exchange, gold or silver, that the federal government or any state could be required by statute to receive in payment of taxes and other debts. Traditionally, as defined by Congress, lawful money only included gold, silver, and currency notes redeemable for gold and silver on demand. In a banking law context, lawful money was only those forms of money of exchange, the forms just mentioned, plus U.S. bonds and notes redeemable for gold, that constituted the reserves of a national bank prior to 1913. All right. So, date of creation of the Federal Reserve Bank. See lawful money, Webster's New International Dictionary, 2nd edition, 1950. In light of these facts, I conclude that plaintiff and defendants exchanged reciprocal credits involving money of account and not money of exchange. No lawful money was or probably ever would be dispersed by either side in the covered transactions. All right, now you can read this for yourself and go and study it. There's a variety of different documents. I'm going to put some links to some things. Perry versus the United States, FASB number 95, modern money mechanics. There's a plethora of things, the velocity of money. There are a plethora of things that you can read. All right, but you need to come in prepared if you're going to make these kind of arguments and allow the judge to give testimony to something without challenging him on it. You know, he said, well, U.S. dollars will define U.S. dollars for me. What is a financial institution? A lot of people don't know what a financial institution is. So right here, as we can see in 31 USC 5312 definitions of application, financial institution means an insured bank, a commercial bank or trust company, a private banker, which is what you are, an agency or branch of a foreign bank in the United States, any credit union, a thrift institution, a broker or dealer registered with the Securities and Exchange Commission under the Securities Exchange Act of 1934, a broker or dealer in securities or commodities, an investment bank or investment company, a currency exchange or business engaged in the exchange of currency, funds, or value that substitutes for currency or funds, an issuer, redeemer, or cashier of travelers' checks, money orders, or similar instruments, an operator of a credit card system, an insurance company, a dealer in precious metals, stones, or jewels, a pawnbroker, a loan or finance company, a travel agency, a licensed sender of money, or any other person who engages as a business in the transmission of currency, funds, or value that substitutes for currency, including any person who engages as a business in an informal money transfer system, or any network of people who engages as a business in facilitating the transfer of money domestically or internationally outside of the conventional financial institution system. A telegraph company, a business engaged in vehicle sales, including automobile, airplane, and boat sales, your dealerships and financial institutions. Persons involved in real estate closings and settlements. Persons involved in real estate closings and settlements. The United States Post Office is a financial institution, an agency of the United States government or a state or local government carrying out a duty or power of business described in this paragraph. A casino, gambling casino, or gambling establishment with an annual gaming revenue of more than $1 million. Right here, you can see these right here. You're going to read this yourself, okay? But you see right here what a financial institution is. All I'm trying to do is change your paradigm. When you're in court and you're having these discussions, you need to know all this kind of stuff. You need to know the definition of an account. You need to know the definition of a deposit. You need to know what all of these words mean so you can understand what banking is. Banking is not just dealing with these intermediaries that are Bank of America, Chase, and things of that like that. These are middlemen, okay? We have one really financial institution. That's the United States Treasury. The Federal Reserve is a private central bank operating provisionally in this country. We don't know who owns it. It is not a part of the government or anything. Wake up, people.
No, I haven't paid in US dollars.
Or anything evidencing US dollars, like a check, credit card, anything like that.
Once again, this is why it's important to know how to put together a negotiable instrument. All right. You need to know how to put together a negotiable instrument. What type of instrument did you give? He just gave a signature and he thought that would suffice. But that's just a banker's acceptance. What instrument did you use to convey the credit?
So this is
No, that's a yes or no.
Can you repeat the question, Yana?
Have you, let me just break it apart so we get it real clear. Have you paid for the months of October 2022, November 2022, December 2022, January 2023, or February of 2023? Have you paid to anything to Peninsular Place in US dollars?
No, Yana.
Have you paid anything to them that is evidence of an account which holds US dollars?
Yes, Yana.
What? And what account is it attached to? You better be careful about answering my question. Because if you're telling me that you gave them or paid them something that evidences an account that can access US dollars, show it to me.
Anything you say can and will be used against you. You need to be careful of your words. I can't tell you the number of times I've heard judges give that type of warning to people that come before him who like to use these words like pay. And I keep constantly telling these people, stay away from that word pay, but people just don't listen. They just don't. They'll learn though when they start getting locked up.
You said that's access to US dollars? Right here.
What is that? What Mr. Fantera just gave?
Yes,
How does that access US dollars?
because Your Honor, this account, I'm the holder and I have the interest.
Then show me the balance on that account.
First of all, in any of these processes, you're not the holder, you're the holder in due course. That's under UCC 3-302. It doesn't appear that he understands that. And this is another reason why you do a secured party process, because your bond is the account that has the value on it. And the UCC 1s and UCC 3s attest to the debits and credits that are being taken from that particular account. You have a statement of account. That's why you do a secured party process.
They show you the balance?
Yep.
Just showed you the balance.
No, you haven't shown me anything. Show me the balance on the account. If you give somebody something that evidences that they can access US dollar, then there is a balance on that account in terms of what you're giving them. Much as if somebody gave a check to them, they would be able to show the account for which they can then present that check and receive US dollars. Show me that account, Mr. Lane.
Like I said, Your Honor, I don't know what else you're asking for. This is
No, you know exactly what I'm asking for.
you're asking for something that's coming out.
Something that evidences that by that piece of paper that you've given them, that they can access US dollars.
Okay. I don't have any other account besides this, Your Honor.
You don't have any what?
I said I don't have any other evidence besides this right here.
That does not show me that they can access US dollars.
Okay.
Where would they take that to, in your mind? Where would they take that to access United States dollars?
Put it on the ledger.
Where would they take it to access US dollars?
Okay. So, Your Honor, so I got a question. As far as landlord and tenant relationships, it's in here.
I'll try to answer your question as soon as you answer mine.
Okay.
Where would they take it to access US dollars?
They will take it and take the check and put it on the ledger with my credit. Because if I owe something, Your Honor, it would be in the negative balance. How can I pay something that's in a positive balance? How can
You don't have a positive balance.
this is
You have given them a piece of paper that you yourself just said is a check. So where would they take that?
I mean, I know this stuff and I'm having trouble following him at this point. Obviously, it has to be taken to a financial institution. Okay. In our situation, it's the Treasury Department, but there's a particular private process that is associated with that, and he doesn't seem to understand that. Once again, this is why you do not do processes until you completely understand it from A to Z. If you're not sophisticated, you shouldn't be trying to do this.
To access your account
so, Your Honor,
and receive US dollars.
they're acting in dishonor. They're taking it and they never said anything about or object to it. So it was off.
Oh, they're objecting now, certainly. Where would they take it, Mr. Lane?
This is why you do a secure party process, because then now you could tender them a negotiable instrument of which they'd have to make presentment. And then if they would have to come back with some sort of protest and allow you an opportunity to cure if there were insufficient funds or something to that effect. And it would keep the judge effectively out of it. You know, you could tell the judge something to the effect of, I'm sorry, Judge, but that's not for you to make a determination. That's for counsel to take that back to his client, and they could return it to me with evidence of a defect from a qualified third party and allow me an opportunity to cure. Absent that, sir, I would consider this matter settled and closed. But he didn't do any of that. He don't know how to use negotiable instruments. He doesn't know what presentment means. He doesn't know anything about banking. So why are you doing this?
So where will they take it? I mean, as far as they have a security deposit deposition bond. So they have it in a financial institution.
What financial institution
I'm not.
would they take it to get cash from your check, as you call it, that would then be debited from your account? Where would they take it?
So debited. So what about the credits, Your Honor?
I don't see a credit.
On this paper, it says credit payments and credits.
That's not what it means. To the extent it says that. You have no credit. Where would they take it to get US dollars?
At that point, if he says that's not what it means, then I'm saying, well, I will conditionally accept the honorable judge's contention. It doesn't mean that upon proof of claim, you can present some sort of statutory authority with the definition of what it means.
So where would they take it? They would take it out of my trust, Your Honor.
Out of your trust.
Yes.
Where is this trust located?
We all have a trust in me.
Okay, let's say we all do. I'm not accepting your premise, but let's say we all do. Where is your trust located?
Okay, a trust is an agreement. We have a situs of a trust, which is the location of the trust, which are the laws that govern the trust. But in this particular situation right here, the trust agreement and the processes that we use are located on the bond, which the holder of that bond is the Department of Treasury. All right. There are specific instructions that are on that bond, which constitute an indenture agreement and makes the Secretary of Treasury a trustee of that particular bond in that particular account. So it's located with the Treasury Department. But he needs to understand a trust is an agreement. It's an agreement.
I'm not sure where it's located, Your Honor, but
So if they wanted US dollars for this thing you purport to be a check, you can't tell them where to take it.
in the Treasury,
Which treasury?
the Treasury.
Oh, so they have to go to the US Treasury with this thing that purports to be a check.
This right here really pissed me off because this was a sovereign citizen answer right here. I mean, this right here, just the people, they're going to make videos out this and clown you, guy. You're going to get clowned.
Really?
They were pulling from the Treasury. That's why they asked for my information.
Who is pulling from the Treasury?
Peninsula Place, Your Honor.
So Peninsula Place is pulling from the US Treasury.
They got the account attached to my name with my social and my information.
So they're pulling from the US Treasury because of that?
The right support can give you confidence in the face of.
Say that again?
So because of that, they're pulling from the US Treasury?
I mean, they're charging the account. So this account has my information tied into it, which is showing that it's already prepaid. So what they're trying to do is Peninsula is trying to make me repay.
You've never paid anything. So they're not trying to make you repay. They're trying to make you pay.
Your Honor, so how did we get here if I never if I provided my information to Peninsula Place?
We got here because you have never provided them anything
Okay.
to pay on this account in US dollars or anything evidencing US dollars. That's how we're here.
Okay, I'm going to stop right here because as you can see, he keeps talking about paying for something. When we set off, what we do is set off debt using private credit against public liability. This requires you to know public and private, which strongly suggests that individuals read the book, What Does Acceptance for Value Mean by Byron Beers. He's going to give you a very technical understanding of how the credits pass from the private into the public. And all this terminology. This is definitely, if you're trying to discharge debt and you have not read what does acceptance for value means, I don't know what to tell you. But in situations like this, I just don't want to do it. I'm going to do some more reviews of some other videos. This was kind of long. It was kind of cringy, kind of hard to watch. I do have respect for the young man for having the temerity and the tenacity to try and do a process like this, because this is the only way that you learn. But I would just like to caution individuals out there, before you get involved in processes like this, understand what you are doing. Understand what you are doing first. Lots of documentation out there that you can read, because you got to stop this, because these people are going to keep calling you sovereign citizens, putting videos out here on Front Street, and it's going to make the whole movement look like a sham. And then you're just going to basically insult all the years that very, very intelligent people have contributed to this particular movement. All right. Just because you're trying to get out of paying rent. The universe abhors a vacuum. There is no such thing as something for nothing. Peace to the gods.